Hello, this is Dr. Rukas again. You're a little over halfway through the course, and I want to invite you to do Module 4, which is going to be a hodgepodge of things. We're going to be looking at probation and parole, civil liberties, and accountability. Now, I'm not going to go over a lot of probation and parole because you do have this in other classes, but I want to give you a brief history of it and show where we are right now in the system. Probation and parole was originally invented in Boston by a gentleman by the name of John Augustus. And what John Augustus wanted to do is he wanted to create a system where instead of focusing on punishment, uh, interactions with the criminal justice system instead would be focused on rehabilitation. And the way that he did this was he took individuals from the court, brought them into his business, served as a mentor, and then eventually worked with them so that they could start their own businesses and function on their own. This is still the guiding principle of probation and parole. However, as it has evolved over time, probation and parole instead has become more an instrument of law enforcement as opposed to an instrument of rehabilitation. Um, and and the goals have become much more closely aligned. It's more focused on returning errant probationers and parolees into jail or prison than it is truly on rehabilitation. Now, there's a number of reasons for that, including increased caseloads, as well as decreased budgets. And we also must keep in mind the power of the Get Tough on Crime movement that's characterized criminal justice since the 1980s. Now, the bulk of my lecture today is going to focus on civil liberties, because civil liberties are a double-edged sword. We are the United States of America. And one of the things that makes the United States of America the great country that it is the fact we have a constitution that is designed to protect our rights. We have a number of rights that are enshrined in the Bill of Rights that was added to the original Constitution shortly after its passing. The Bill of Rights is something that we cherish, and it's something that, again, a part of our national identity and makes us who we are. Problem is a number of those civil liberties that are protected by that makes it really hard to enforce public safety. Law enforcement, by its very nature, is evasive. Police are one of the few institutions in society that can go in and break a family up without any advance notice. So when we have an institution that has that much power, we need to have control, and we need to have control of individuals as well. And one of the questions we've struggled with, and we still don't have an answer for that yet, by the way, is where's the proper balance? How can we serve both? Now, I'm going to go through a few amendments in the Constitution, briefly go over what they do and what they protect, and how they can create problems. All right? Well, not necessarily create problems. That's not the word. But how these civil liberties are working in a contemporary environment, all right? And in that contemporary environment, challenges that are faced and those challenges that can be posed to law enforcement. Now, many times, we also must keep in mind, and I'm going to get to the First Amendment in a second, is that our system is set up in a way that it's better for a guilty person to go free than for an innocent person to be arrested. As a result, we have very strong protection of these civil liberties, and police that do not respect these civil liberties can cause problems, and many times valid arrests can be taken away. All right. First Amendment I want to talk about is the First Amendment. All right. This amendment guarantees freedom of expression and freedom of the press, and law enforcement cannot intervene with that right. And as a result, people have the right to self-expression. However, that self-expression can sometimes create public safety issues that have to be addressed. For example, let's take a look at what happened in Charlottesville. We have two sides, both of which are exercising First Amendment rights. All right? Law enforcement's put in a situation where you have two groups that are adamantly opposed to each other. All right? One of which, I would argue, they're bending over backwards to protect the First Amendment rights of those that in this case, the white nationalists, which our Constitution guarantees a right to self-expression. But when you have two groups that just do not speak the same language, that becomes very difficult for law enforcement to maintain peace. And in Charlottesville, where you have such an extreme view being held, you can create situations where there's violence. The other thing that comes with the First Amendment is that citizens have the right to take videos and video police everywhere. That means that officers need to assume that they are always going to be on camera, and the Supreme Court has actually come in and said that police have the right, that citizens have the right to video police whenever they're there. So that's something that has to be kept in mind, and has brought great transparency to law enforcement, but that transparency has often come with embarrassment. The Second Amendment. And this is really interesting because the Second Amendment, law enforcement, which of course is the right to bear arms, law enforcement personnel have two beliefs. They have their personal belief, which is their right to bear arms, and then they have their professional belief, which is, as an officer, people want as few guns out in the community that they're policing as humanly possible, especially if crimes are involved. All right? As a result, various police associations normally will lobby against Second Amendment rights, not necessarily Second Amendment rights, but lobby against expansion of the Second Amendment, and will lobby for gun control, which is a really interesting position to have because officers, again, value their own rights to own firearms, which is something that's enshrined in our Second Amendment. And that creates difficulty because officers don't want to confront violence, and we have to, again, find a proper balance there of where the Second Amendment should lie. And one of the biggest issues we have, and this is one that everybody has, is are there actions and what action should nullify this right? Obviously, nobody wants the local serial killer to be able to go to a shop and purchase a firearm. But then where do we draw the line? Where do we draw the line at a point where we allow people to keep their Second Amendment rights, but also protect public safety? Tough question, and a question that we probably will not have answered for a very long time, because it's difficult to find a balance between officers fighting deadly force and a constitutional right that enshrines the right to have that deadly force. The Fourth Amendment, which is the right to privacy. All right? And here the right to privacy talks about the right to search. All right? Officers must follow proper protocols and when needed, should have warrants before they go searching people. All right? Why is this important? We all have the right to privacy. Most people would not want a police officer to have the right to just pull their cell phone out and look at all the communication they've had with friends, family, and all of the private information that's on there. All right? And people don't want police to have the right to randomly search a house. So normally there needs to be, again, some sort of warrant, probable cause, or reasonable suspicion, depending on the appropriate standard. And if that standard is not followed, any information that comes from that search is null and void. It's fruit of the poisonous tree. Now, as a result, officers need to follow proper procedures. Where this becomes problematic is if an officer doesn't follow proper procedure. The most dramatic example is an officer that didn't have a right to search a house opens a door and finds upstairs somebody holding a knife over a victim. If the officer did not have a right to search that house at that point, that evidence can become null and void. So it's something we have to be really careful of. And while we all want to protect ourselves from search and seizure of the police, we also need to do it in such a way that there's a reasonable way for officers to search and get information that they need in order to enforce the law. The Fifth and Sixth Amendment, which is the right to self-incrimination. What that basically means is people have a right to a lawyer, and they have a right to say nothing. Now, the Supreme Court has looked at this, and this creates a really interesting dynamic. People have the right to say nothing, but if they do say something, it should be truthful. Even if police have the right to not be truthful in an interrogation. Citizens do not enjoy such a right. Now, obviously, nobody wants people lying to the police, okay? However, the issue arises is that police interrogation techniques have been perfected over time, and they're very effective to a point where those of you that are going to be in the death penalty class will have to look at issues of false confessions. Police interrogation techniques are when administered in the proper way, can be so powerful that they can cause people to confess to crimes they don't commit. And the question is, again, where do we find balance? Again, you notice I'm not taking sides on any of this. I'm pointing out that we need to find balance, and these are challenges that we face. Oops, sorry about that, everybody. And the Eighth Amendment. Another problematic, not a problematic amendment, but a challenging amendment, all right? It protects against cruel and inhumane incarceration. Now, the Supreme Court, and also, by the way, protects against excessive force. Problem is what's cruel and inhumane and what's excessive? Sounds great that we don't want cruel and inhumane punishment. And the Supreme Court has said that no one has a right to comfortable incarceration. But what constitutes cruel and inhumane in a backdrop where we can send someone to an institution like a prison? How do we make a prison humane? But yet, how do we still make it punish? And also here, another issue to look at is the issue of excessive force. Again, it's nice to say that people should not be using excessive force, but what constitutes excessive force? Now, there have been systems that have been put in place. The problem that comes with this, though, is that the emotion and everything that's going on at the moment, there tends to be a lot of armchair quarterbacking going on. And what I mean by armchair quarterbacking is that the person, it's people that weren't involved in the situation that are normally making the judgment call. And it doesn't always take into account. It's impossible to schematically outline a whole range of human emotion and figure out what's excessive and what's not. So when it comes to excessive force, even though we have a number of standards, by and large, we as a community use a standard that we know when we see it. And that creates a very difficult environment for officers to operate in. As such, come to the final issue here, which is accountability. And when it comes to accountability, I'm going to bring up something I call the fallacy of the one, which happens a lot in criminal justice and tends to dictate criminal justice policy. And what I mean by this is the fallacy of the one. And what that means is if one person does it, everybody must do it. So as a result, if we see one officer using excessive force or one officer not acting the way that he or she should, we tend to think all officers do it and then come up with public policy that's based on the one. That can be problematic. So with that, I'm going to close this lecture out, and I hope I've given you a bit to think about this week. Have a great one. Take care.